Good afternoon, everybody. It is Monday, November 24th, 23rd or 24th, and this is Truly Sinister. My name is Wendy. Yesterday I covered Kelsey Fitzsimmons updates, but I actually entitled my stream last week at a glance, which I should change that because it was more or less Kelsey Fitzsimmons. But I do remember that I was trying to find a video to show you guys of the new candidate for the Norfolk County DA. And I do believe that I found the video. Praise Jesus, right? My God, it's like, yeah, anyway, oh shit. Let me find it. I kept it, I promise you guys, I kept it this time. I don't want to. Nope. It's gonna make a liar out of me again. God damn it. Let me see. We will see. Oh shoot. That's not what I meant to do. Subscriptions. Oh, Jesus. I just want regular YouTube. I don't want my channel. I don't want any of that. I just want regular YouTube. And I think, here we go. Nope. Yes. Okay, so let me find you guys. Share my screen. Jeez. And here we go.
So easy to become a podcaster with Riverside. First, go to Riverside and open an account. When you're
Everyone deserves to live in a community where we feel safe, where we have trust in our leaders to serve with competence, integrity, and professionalism. My name is Adam Deitch. I grew up in a community with safe streets, good policing, and faith that those in power were honest, hardworking public servants. Until 10 days ago, prosecutors I faced throughout Massachusetts: bank robberies, gun and drug cases, child exploitation, cyber stalking, and all kinds of fraud. But what I've spent most of my time doing is trying to root out public corruption in our state, including and especially right here in Norfolk County. I left my job in the U.S. Attorney's Office because when I see a problem, I want to solve it. Over the course of my career, I've learned that the overwhelming majority of police officers and prosecutors work hard and do the right thing. I've also been proud to stand shoulder to shoulder with members of law enforcement who work to keep our streets safe. But I also know there can be grave consequences when they take shortcuts, rush to judgment, and then stubbornly won't consider other possibilities. That's what's been happening in Norfolk County for far too long. That's why I'm running for Norfolk County District Attorney as a prosecutor, not a politician. Norfolk County deserves leaders we can be proud of, who serve honesty, transparency, and accountability. This campaign is about more than electing a new district attorney. It's about building a culture of accountability and integrity where professional police work for victims, not insiders, and where we follow the no matter where it leads or that standard. I live by prosecution throughout Massachusetts, and that's exactly what I'll do as the next Norfolk County DA. Together, let's build a district attorney's office we can be proud of.
Okay, all that was muted. Sorry about that. Anyway, I wanted to show you the campaign video for Adam Deitch, which you guys saw. But now we're going to go over Aaron Spencer updates. Last time I think we went over the Aaron Spencer case, the updates for his case. We read the motion from the defendant to exclude evidence, and it was evidence that the state thinks proves premeditated murder, because there were some things he said in the months prior to the shooting that they think show premeditation. So right now we're going to go over the state's motion and eliminate to exclude evidence. The state of Arkansas, by and through Deputy Prosecuting Attorney John Huggins, for its motion in limine to exclude evidence. 1. The defendant is charged with murder in the second degree in the killing of Michael Fossler. 2. Spencer's defense team has given notice of 3 potential expert witnesses at trial. 3. The curriculum vitae given to the state are attached as provided. See Exhibit A. 4. In reviewing, it appears the subject matter of expertise for the three would all be irrelevant to a murder charge or any potential justification defense. 5. The Arkansas Rules of Evidence address expert testimony in Rs. 702, 703, 04, 05, and 403. 6. The state is requesting a pretrial hearing for the court to determine any relevancy or admissibility of any proposed defense expert witnesses. Wherefore, the state moves to exclude witnesses identified as experts by the defense as irrelevant. So this is, okay, this isn't what I thought it was. This is the list of all the expert witnesses that the defense plans on calling. And this is, okay, so now we're going to go over the let me see if it's big enough for you guys. We're going to go over the reply to the state's response to defendant's motion in limine to exclude evidence. Okay. The defendant, Aaron Spencer, by and through his attorneys, Aaron Casanelli and Michael Kaiser, states for the reply to state's response to defendant's motion in limine to exclude evidence, Spencer is charged with the second-degree murder of Michael Fossler, specifically that Spencer knowingly causing the death of Fossler under circumstances manifesting extreme indifference to the value of human life. Arkansas Code, whatever. Spencer has asserted the defenses of justification pursuant to Ark Code. A person is justified in using deadly physical force upon another person if the person reasonably believes that the other person is 1. Committing or about to commit a felony involving a physical force or violence, 2. Using or about to use unlawful deadly physical force, or 3. Imminently endangering the person's life or imminently about to victimize the person from the continuation of a pattern of domestic abuse. Spencer has also asserted a defense pursuant to A, conduct that would otherwise constitute an offense is justifiable when 1. The conduct is necessary as an emergency measure to avoid an imminent public or private injury, and 2. According to ordinary standards of reasonableness, the desirability and urgency of avoiding the imminent public or private injury outweigh the injury sought to be prevented by the law prescribing the conduct. Both statutes are justification defenses under Arkansas law. Okay. The state's charge requires proof beyond a reasonable doubt that Spencer knowingly caused Fossler's death by deliberately creating a risk that was my dog's limping, sorry, that was practically certain to result in Fossler's death. The state must further prove that Spencer did not act under the reasonable belief that Fossler was committing or about to commit a felony involving force or violence against Spencer or Spencer's child, or that Fossler was using or about to use unlawful deadly physical force against Spencer or his child, and that Spencer's conduct was not necessary as an emergency measure to avoid an imminent public or private injury, and the desirability and urgency of avoiding it outweighed the injuries sought to be prevented by the murder statute. Whew, that was a long sentence. Both defenses are to be submitted to the jury if there is any evidence admitted supporting the defense, and if so, the court shall charge the jury that any reasonable doubt on the issue requires the defendant to be acquitted. Thus, the state must disprove these defenses beyond a reasonable doubt. By statute, a justification such as self-defense is considered an element of the offense, and once raised, it must be disproved by the prosecution beyond a reasonable doubt. Roman numeral 1. The state's factual recitation is misleading and omits material facts. The chain of events that led to the death of Michael Fossler began on July of 2024 when he repeatedly sexually violated Spencer's daughter. Not as the state would have it, when Spencer first learned of the horrors Fossler had perpetrated against his child. The chain of events that resulted in Fossler's death definitely began with Fossler repeatedly SAing a then 13 and later 14-year-old child. The chain of events continued with Fossler being arrested and released for those crimes, yet continuing his manipulation and deception so he could continue assaulting the child. Yeah, Judge Elmore let him out. She's got a soft spot for rapists. Until finally someone realized that he had taken her away from her home during the night. Footnote 1. It seems that the state is sensitive about the language used to describe the 67-year-old Fossler, and I said 61-year-old, 67, whoa. 67-year-old Fossler picking up his 14-year-old SA victim so he could take her to another location to commit more crimes against her. But surely no one can argue that he did not take her away from the home in his vehicle that night. Because the prosecutor's trying to say that she snuck out, that she wasn't kidnapped. But she's a minor, so she can't make that decision, so it's kidnapping. When Fossler realized that the Spencers realized that he had taken control of her that night, he fled with her, refusing to surrender her. The chain of events that led to Fossler's death began and ended with Fossler's criminal acts. The state's suggestion that the chain of events that resulted in Fossler's murder was Spencer's looking for information about Fossler from the mutual acquaintance is yet another attempt to distract from the, quote, chain of events, end quote, that Michael Fossler started and perpetuated until his death. It is yet another deeply concerning indication of its failure to blame the blameworthy, the dangerous pedophile, instead of the man who found his daughter under the control of the pedophile. And while the P was facing multiple life sentences and then some for his abuses of her. And then some. He was facing multiple life sentences and then some. Okay. This is a cold read, sorry. The state has also repeatedly manipulates the statements and evidence in its response. For instance, the state says that Spencer told Higginbottom, quote, I don't call anyone. Don't call the police, end quote. Although that is not precisely what Higginbottom told police shortly after. When he came to speak with Miss Higginbottom, this is how they know Fossler. I believe it was her boyfriend. The person through whom Fossler accessed the child, Spencer actually said, "Don't call anybody." She felt because a family member had been through a child sexual SA incident and the local police department in this jurisdiction had re-victimized her instead of helping her. She explained that Spencer had just learned of the assault from his daughter, although she did not seem to believe it was true, and he wanted Fossler's contact information. The state also omits the context as to the history of the family connection between the Spencers and Higginbottom and her role in the events that led to Fossler's abuse of the child. The state's response then purports to describe the events when officers arrived at Spencer's residence in regard to the rape allegation. In addition to the family's knowledge of local law enforcement's failure to assist in a prior child SA investigation, Spencer knew that Fossler had a history of law enforcement and military. Had a history in law enforcement and the military. Although the state focuses solely on Spencer's visceral reaction to learning details of his daughter's repeated rape by Fossler, the reality is that within about 7 minutes, the Spencers agreed that the child would speak to a female officer, and the conversation moved to exchanging information and proceeding with an investigation. Spencer and his wife then spent the next hour and 8 minutes or more talking with officers about the family history, the situation that led to their child interacting with Fossler, and information the child had reported to her mother, while waiting on other officers to respond and filling other time with cordial discussion about everything from the military to animals to movies. Spencer and his wife invited officers to park in the driveway, invited them to sit on the porch, and offered them water. They completed forms and signed paperwork, answered questions, and cooperated with the officers' requests. After waiting nearly an hour, an investigator arrived and explained that another investigator would be assigned to the case, so she would not be speaking to the child that day. She interviewed the Spencers, and they provided her with all of the information she requested, including names, contact information, and every detail they knew to that point. They agreed to wait for a detective to contact them the following day to set up an interview with the minor. Spencer thanked the officers for coming, and they cordially departed. The state's attempt to reframe this interaction as one in which Spencer was mainly concerned about the identity of the mandatory reporter and his beliefs in the adequacy of the judicial system is not just false, but completely tone deaf as to the situation the Spencer family suddenly faced and their fierce concern for their child. The state dismisses that Spencer did not refuse the officer's entry or refuse to cooperate or allow his child to cooperate. It certainly doesn't acknowledge the more than hour of he and his wife providing officers with any information they could to help put Fossler in jail. Any information they could to help put Fossler in jail. While Spencer was worried for his child and angry at his daughter's rapist and the person he felt protected the rapist, Prince, and who they believed lied to officers, he was quickly calmed and cooperative. Footnote 2. Spencer and his wife were both concerned that the person who contacted police had lied to them, as they knew she was not a mandatory reporter. They were not told that she had spoken to a third party who is a mandatory reporter on any of the other context of that conversation. They believed she had previously misled them about their child and had concealed the child's victimization at the hands of Fossler, her boyfriend. Yeah, Higginbottom was Fossler's girlfriend. They were upset because it seemed, with the information they had at the time, that she was again deflecting from Fossler's actions by accusing someone in the Spencer family of wrongdoing. Okay. It is difficult to imagine many fathers not feeling and behaving the same way when presented with such horrific and shocking circumstances. What Spencer said then and believes still is that a parent has an absolute right to defend their child against someone who is presenting an imminent danger of harm, like manipulating a minor victim to have sex with him while awaiting trial for numerous sex crimes against her, when the judicial system cannot or will not protect them. And what matters is what actually happened, not what the state tries to piece together from picking and choosing words spoken months before the event that put the child directly within the control of her rapist. What really happened is that Spencer stood down. He did not attack Fossler when he confirmed his contact information. He went back home to talk to his family. Before they could do so, while preparing their child for the process of reporting this that she was about to go through, officers showed up unexpectedly. The next day, they delivered their child for a forensic interview and allowed the criminal process to play out. They did interviews, delivered, and consented to searches of electronics, provided witness information, etc. Fossler was just consented to, okay, etc. Fossler was arrested 4 days after the initial meeting at the Spencer's residence. He was seen by a judge the following day, and it seems an order out of the circuit court was entered imposing a mere $50,000 bond and generic no-contact order prohibiting Fossler's contact with any minor. It was not specific to the Spencer's child and did not include any restriction concerning their property or other places the child may be present. Despite the plentiful evidence confirming the use of social media platforms to commit the offenses, he was not restricted in his use of social media. He was not required to report to anyone associated with the court or law enforcement, and neither his internet usage or physical movement were monitored in any way. The state's response then begins to describe the early morning of October 8th, 2024, as if Spencer planned this night of his daughter being essayed by a 67-year-old man in order to efficiently and effectively, quote, take the law into his own hands, end quote. Such insinuation is offensive and absurd, and once again favors the P instead of the victim. The state's own probable cause affidavit for the arrest of Aaron Spencer contradicts much its description of the morning Fossler died, and certainly omits significant information about the events that led to Fossler's death. See affidavit for warrant of arrest attached as Exhibit 4. The affidavit states that Spencer told officers he had been woke up by his dog barking, which was uncommon, and went to check on his daughter. Events that occurred earlier in this year. Due to events that occurred early in the year, I don't know what that means. Aaron Spencer stated that the dog was in his daughter's bedroom, and when he opened the door, the dog continued to act out of character. Aaron Spencer further explained that when he looked closer at what he thought was his daughter in bed, he realized that it was actually a stuffed animal with his daughter's hoodie on it. Aaron Spencer stated that he became scared of what had happened to his daughter and had his wife call 911 to report her missing. Aaron Spencer then stated that he left his residence and began to search for Michael Fossler and his daughter. Aaron stated that when he arrived at the intersection of Highway 236 East and Highway 31 North, he observed the white Ford F-150 belonging to Michael Fossler run off of Highway 31 North onto Highway 236 East, heading towards his residence. Aaron Spencer then stated that he turned around, attempted to stop the vehicle by flashing his lights and blowing his vehicle's horn. Aaron Spencer stated that he was in fear for his daughter's life and continued to pursue Michael Fossler east on Highway 236 East. Aaron Spencer explained that when they arrived at the intersection of Highway 236 East and Highway 13 North, he hit Michael Fossler's vehicle in the rear, causing it to slide off the roadway. Aaron Spencer then stated that he exited his vehicle with his firearm eye in hand, and ordered Michael Fossler out of his vehicle and to lie down in the ditch. Aaron Spencer stated that he observed his daughter trying to exit the passenger side of the vehicle, but it appeared that Michael Fossler had grabbed her and stopped her from getting out. Aaron Spencer then stated that Michael Fossler exited his vehicle and had something in his hand, but did not know what it was. Aaron Spencer stated that Michael Fossler then lunged towards him, saying, quote, "Fuck you," end quote. Aaron Spencer stated that he then opened fire on Michael Fossler, emptying his weapon before jumping on top of him and pistol whipping him. Aaron Spencer then stated that he got his daughter out of the vehicle and returned to his truck, where he reloaded his weapon and called 911. Spencer certainly never told officers he thought Fossler had entered their home and forced the child into his truck. But when Heather and Aaron Spencer found their daughter's bed empty, they were worried given what she had recently been through. They decided Heather would call 911 and he would begin searching for her in the area. They learned about that time from a family member that Fossler had recently contacted the child, and that they were understandably panicked. They were terrified that Fossler would not only SA their child, but that he would kill her or disappear with her, knowing that she was the only critical witness to crimes that would put him in prison for the rest of his life. Like any normal father, Spencer left his wife to stay on the 911 call while he went out searching for her. Contrary to the state's suggestions, there is absolutely nothing about him doing this that is unlawful or wrong. In fact, it is exactly what most anyone would do. Okay, so we basically have read all this stuff. When we went over the motion in limine to exclude this evidence, but I'll go on a little bit farther and see if there's anything different. Okay, let's skip forward a little bit, because this is basically reiterating everything that was said in the initial motion. Okay. Like any normal father, Spencer left his... Okay, we already read that. Contrary to the state's suggestions, there's absolutely nothing about him doing this that is unlawful or wrong. In fact, it is exactly what most anyone would do. Contrary to the state's misrepresentation in his interview after the shooting, Spencer did not say he was, quote, vigilant for, end quote, Fossler that night. Instead, he explained that he learned what Fossler looked like, where he lived, and what vehicle he drove because he was aware that no one was monitoring Fossler. And while he did not watch Fossler, he needed to know if Fossler was nearby. He was worried that without any real barriers in place, Fossler would seek the child out and hurt her again. He explained that he thought he had seen Fossler driving near the Spencers' home several times, but he was not certain it was Fossler, and if it was, Spencer would not confront him and instead would let the police do their job. But he remained aware of Fossler and aware that no one was watching him. So, as he explained to investigators, Spencer stayed vigilant for Fossler, for Fossler if he came near their home. Spencer said nothing to investigators about immediately getting in his truck that night to look for Fossler because he was vigilant for him. He was, however, vigilant in his desire to find his daughter. While Spencer was looking for his daughter, he happened to pass Fossler's truck as it turned onto Highway 31, several miles from where the Spencer's residence is located on the roadway, and Spencer saw his child in Fossler's truck. Spencer turned around to follow, and for miles, Spencer honked and flashed his lights, but Fossler sped up, fleeing with the child towards an intersection that would take them out of the area. Before that could happen, Spencer, having been trained in military tactics and maneuvers for disabling vehicles while avoiding significant injuries, pushed Fossler's truck into a driveway. Fossler exited the truck, coming towards Spencer aggressively with something in his hand, and Spencer shot him, unloading his clip. Fossler jumped into the ditch and continued to move and curse, and concerned that he may have had a weapon, Spencer hit Fossler with the gun to abate any further threat. The state suggests that Spencer had other options that night, including that he could have called 911 when he found Fossler with his daughter. That kind of hindsight is inappropriate and irrelevant. First, and most importantly, there is no law whatsoever in the state of Arkansas that requires any citizen to call 911 in the face of imminent danger. Arkansas law provides every citizen the right to protect themselves and their family from threat of harm. There is no condition to call 911 first and see if that works out. Second, Heather Spencer had already called 911, and Spencer knew that. Unless the sheriff's officers were ignoring the call, they were on their way. If it takes a second 911 call to make officers move faster when a child victim/witness in a pending Y felony case is missing, that is a significant problem for the community. Third, the state's representations about Spencer's phone are simply wrong. Spencer explained to investigators that he could not get his phone unlocked while driving, and also that when he was going so fast, he didn't want to have a wreck making a call. Not that he was driving so fast he could not unlock his phone. The phone records confirm that this is true. He makes no call between the time he located Fossler and the shooting. He spoke with a family member before finding Fossler with his daughter, and while a family member sent him text messages during the interim time, the forensic examination does not establish that he saw those messages at the times she sent them. A critical review of the phone data proves that the times correspond to when a text is sent and received and do not reflect an action to use the phone to read the messages. Once he saved his daughter, his first and only call was to let his wife know she was safe. Although he did not reach her, his next call was to 911. The state's assertion Spencer, quote, had good reason to believe his daughter had snuck out of the house and had not actually been kidnapped that night, end quote, is outrageous. State's response at 3. It is as if the state is portraying the relationship between a child SA victim and her abuser as typical and consensual. The idea that a parent in this situation would reasonably believe that their child was safe in this circumstance is preposterous. Whether or not she was forcibly removed from her home, Spencer and any parent in that circumstance had good reason to believe that the child was in danger. This is especially true here, where the rapist with control over the child is facing life in prison and the child is the sole witness. Even though it matters not how you label it, most reasonable parents would believe this was kidnapping too. Footnote 3. Goddamn right. The defense believes Fossler did legally kidnap the child and does not concede otherwise. However, it is irrelevant whether his conduct technically met the illegal definition or the legal definition for kidnapping. The comments also demonstrate a reprehensible, quote, blame the victim mentality. The state seems not to understand the victimization of children by pet peas like Fossler. The child was 13 years old when Fossler began to groom and assault her, turning 14 years old shortly before he was arrested in July of 2024. Footnote 4. Grooming is behavior that manipulates and controls the child as well as those around the child to perpetuate the essay of the child. Among many other things, he told her often how much he loved her and manipulated her into believing him and believing that she loved him, even when he hurt her. Unfazed by the dozens of crimes he faced for his assaults against her and a no-contact order prohibiting him from contacting a minor, Fossler continued the pattern of grooming the child so that he could maintain his ability to control her and to sexually violate her until the very end. Neither the Spencers nor any reasonable parent would ever consider the circumstances as just a teenager who snuck out of the house. The state seems to be arguing that it was unreasonable for Spencer to believe that Fossler presented a risk of harm to Spencer's 14-year-old daughter. If he persuaded her to sneak out instead of forcing her out of the home, the state also seems to be arguing that Fossler did not commit any crime in persuading his 14-year-old victim to leave the house so that he could pick her up and, at a minimum, have sex with her. But Fossler committed multiple felonies against this child that night. Yet the state seems to reinstate that Fossler did not, in fact, present a danger to this child victim on the night of October 8, 2024, an insinuation that is so flabbergasting it is difficult to comprehend. The state does not, however, offer the last piece of its theory that since the state says Spencer really believed the child willingly joined her rapist that night, he should have called police a second time rather than follow Fossler and secure the child's safety. The state does not explain how Arkansas law requires any person to refrain from acting in favor of hoping for a police rescue in the face of such danger. The state likewise does not explain how its proposed plan of action would have assured the child's safety. The state does not explain how Arkansas law required Spencer to choose to let Fossler flee with his daughter instead of intervening to protect her. Nothing that Spencer said months prior has any bearing on these issues. The only facts that matter are those that put a child victim under the sole control of the P who had repeatedly harmed her. Spencer's anger months prior in no way changes the scenario Fossler created that night. Whether Fossler forcibly kidnapped Spencer's 14-year-old daughter or groomed her so that he could continue to abuse her, if not disappear her, the analysis is the same. Either scenario created a legal duty and legal justification, and certainly reasonable cause, for Spencer to act to protect his child from a sexual predator who refused to leave her alone and who presented a real threat to her safety, both as a victim and witness to his crimes. The suggestion that if Spencer thought his 14-year-old child may have gone willingly with her rapist, Arkansas law requires him to sit back and hope for the best is outrageous. But this is apparently the core issue in this case. Thus, it matters not what Spencer felt or said months prior when he learned of Fossler's grooming and abuse of his child, because on the morning of October 8, 2024, Fossler, by his own choice, posed an imminent threat of harm to his victim, and Spencer had every right and indeed obligation to fight to save her. Roman numeral 2. This is not proper evidence. So, let me make sure that my mic's still working. Okay, sorry. Sorry. What's going on here? I don't know why it's doing that. Let me see. Can you guys see it now? Let me stop and start again, because it's cutting it off for some reason. Okay, share screen. Sorry. Now we'll make it bigger. Okay. The issue for trial is not whether Spencer killed Fossler or whether he intended to kill him or planned to kill him or knowingly killed him. Thus, the 404B analysis does not apply. The issue is whether at the time Spencer's action, he had reasonable cause to believe that Fossler was committing or about to commit a felony involving physical force or violence, or was using or about to use unlawful deadly physical force, and or whether Spencer's conduct was necessary as an emergency measure to avoid imminent injury, where, according to ordinary standards of reasonableness, the desirability and urgency of avoiding the imminent injury to his daughter and or himself outweighed the injury to Foster. These are complete defenses. The state has to prove otherwise beyond a reasonable doubt in order to convict Spencer. Justification is considered an element of the offense and once raised must be disproved by the prosecution beyond a reasonable doubt. Spencer did not, as the state insinuates, stalk Foster and kill him. There you go. Spencer did not allow Fossler to kidnap his daughter and grape her so that Spencer could kill him. These suggestions are absurd. Absurd, period. Fossler made the choice to violate the law and the court's order and to once again endanger his child victim. In fact, he was unrelenting in this regard. Yeah, he wouldn't even let go of her when she was trying to get out of the truck. He'd been caught. What was he going to do, drop her off at home? But he'd been caught, and he's still grabbing onto her and not letting her get out of the truck. I mean, he wasn't going to stop. These suggestions are, okay, Foster made the choice to violate the law and the court's order and to once again endanger his child victim. In fact, he was unrelenting in this regard. Foster created and presented a real danger on the morning of October 8, 2024, not Spencer, and therefore Spencer's initial reaction months prior has no relevance to Spencer's necessary use of force months later. Unless the state is planning to present a theory that Spencer set Fossler up to take his child and assault her on morning of October 8, 2024, so that he could kill Fossler, there is no legitimate 404B issue. The issue for trial is simply whether Spencer manifested extreme indifference to the value of life, or whether he may have had reasonable cause to fear for her safety at the time he acted to protect his child. Whether Spencer also hated Fossler or was angry at him after finding out about Fossler's horrific crimes does not impact this analysis. If he had reasonable cause to believe that Fossler posed an imminent threat to his child, he is not guilty. Whether or not months prior Spencer had said things in anger about not wanting public assistance or thinking it is bullshit to suggest that a person could not protect another person from harm without going to prison, the issue for the jury is whether Fossler's actions created reasonable cause for Spencer to act in fear of his child's safety on October 8, 2024. Allowing the state to taint the jury with emotional reactions untethered temporarily to the events of October 8, 2024 violates Rule 404. Roman numeral 3. The state ignores Arkansas R Evidence 403. The state completely ignores Evidence 403 in its response. Even if relevant under Rule 404B, evidence may still be excluded under 403 if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury. That is precisely the purpose and effect of the evidence at issue. Nothing about Spencer's comments in July 2024 shed light on his actions or Fossler's actions on October 8, 2024. Even in July of 2024, Spencer did not act upon his frustration or anger, which is when he most likely would have, because it's right after he found out about what happened to his daughter. He tried to identify Fossler's residence and his vehicle, and he went home. He thereafter consented to searches and cooperated with investigators. He was, as any parent would be, diligent in trying to keep his daughter safe from Fossler, getting her therapy, limiting her contacts, homeschooling her, etc., and beginning to understand her suffering from the mental manipulation of this man. He was also, as any parent would be, diligent in learning information to identify the person who had targeted and hurt his child, so that his family would be aware if this man targeted her again, which he did. It was only when Fossler actually took his daughter from his home that Fossler presented an imminent danger to her that justified Spencer's actions to protect his daughter. As it turns out, unbeknownst to the Spencers, Fossler had been communicating with the child. Okay, I'm going to take a quick break real fast. Sorry. I will be right back. Okay, I'm back. I'm sorry about that. Let's go on. Okay. As it turns out, unbeknownst to the Spencers, Fossler had been communicating with the child since about a month after his release on bond. With no bond condition or supervision dissuading him, he continued engaging with her and others on social media platforms and had directed the child as to keeping the communication secret. He had picked her up on 3 occasions between his release from custody and the night of October 7th, 2024, without anybody knowing. Holy crap, I didn't know that. On this final occasion, Fossler spent about 4 days or so persuading her to leave her house and go with him for the express purpose of committing criminal sex acts with her. She left the house around midnight, and Fossler picked her up near the Spencer home. Fossler then drove her to his home in Cabot, essayed her, and was driving back near her home when Spencer encountered them. Spencer had no idea that Fossler had continued to communicate with his child after the arrest, and he certainly had no idea that he had continued to victimize her. Like any parent, Spencer went looking for his daughter when she was found to be missing. Once he saw Fossler with her in his custody, Fossler made clear he would not peacefully let her go. Like any parent in that moment, whether or not a 14-year-old child recognized the danger, her parents believed she was in danger in the custody of her rapist, and that Fossler had every reason to harm her to avoid life in prison. Fossler certainly did not, by his own behavior that night, indicate otherwise. To permit the state to try this as a case of premeditation or intentional murder, as if there is no legitimate question as to the risk posed to the child victim that night, or as if Spencer somehow knew and planned to kill Fossler and allowed Fossler to harm his daughter again to do it, would be prejudicial error, allowing the state to try Spencer for his reaction to the initial disclosure of abuse and the gory details, and not on the circumstances and actions that led to Fossler's death. There's absolutely no evidence to suggest that Spencer knew Fossler would take control of the child and create a situation in which Spencer had to defend her, and to allow the state to suggest so is highly prejudicial and misleading. Spencer's comments in July are irrelevant to the issues in the case and threaten to confuse the issues for the jury's consideration and mislead them into a fundamental misunderstanding of the law and how the facts apply to it. Roman numeral 4. Conclusion. Allowing the state to suggest that Spencer's actions to protect his child from her rapist were not motivated by concern for her safety at all, but instead by the panic, anger, fear, or frustration he expressed 3 months earlier, would be prejudicial error. His comments upon learning that his child had been SA'd do not make it more or less likely that he reasonably believed she faced danger when Fossler had her in his control and refused to release her. Any suggestion that those comments demonstrate an intention or plan to act months later, when Fossler actually had control of the child for the purpose of engaging in criminal acts, is illogical, unsupported by the circumstances, and would mislead the jury. The events of October 8, 2024, Fossler's actions and Spencer's response to them are the relevant facts the jury must consider. The state should not be permitted to divert attention from those facts by implying that Spencer responded poorly or displayed bad character when he first learned of his daughter's victimization. Spencer did nothing to harm Fossler at that time, and instead he and his family cooperated with authorities prosecuting Fossler. It was not until Fossler put Spencer's child in danger again that Spencer acted to protect her. There was nothing vigilant about Spencer's actions to protect his child on October 8, 2024. He acted in response to an obvious threat of harm. Although the state apparently disagrees with Spencer as to whether Arkansas law protects a person from prosecution for protecting himself or his family when confronted with imminent danger that is uncontrolled by law enforcement or the judicial system, that decision is for the jury. Wherefore, the defendant, Aaron Spencer, asked the court to grant the defendant's motion in limine and for any other relief the court finds appropriate. Respectfully submitted. And this is the affidavit for a warrant of arrest for the following person. So, yeah. So that is the state's response to that is the defense's response to the state's response for the exclusion of evidence of what he said months prior, because they think that should make him look like he premeditated. Okay, so then they distributed a lot of subpoenas this month for like the EMTs, etc. So they're getting ready for a trial. Okay, now let's see. Then there were some. Let's see. There's some stuff on Discovery. Okay. Okay, so we'll go here. Brief in support of amended motion for discovery. by the defense. So I want to share this. Share screen. Share. Okay, and I'll make it bigger for you guys since it's cutting it off. I don't know why it's doing that. Okay, brief in support of amended motion for discovery. 1. The defendant requests the following material and information that is or may, sorry, I'm going to take myself off screen here for a minute. Okay, let's try that again. The defendant requests the following material and information that is or may come within the possession, control, or knowledge of the prosecuting attorney. A. The names and addresses of persons and prosecuting attorney intends to call names and addresses of persons the prosecuting attorney intends to call as witnesses at any hearing or trial. B. Any written or recorded statements and the substance of all oral statements made by the defendant or a co-defendant. C. Any reports or statements of experts made in connection with this case, including results of scientific tests, experiments, or comparisons. D. Any books, papers, documents, photographs, or tangible objects the prosecuting attorney intends to use in any hearing or at trial or that were obtained from or belong to the defendant or co-defendant. C. Any record of prior criminal convictions of persons the prosecuting attorney intends to call as witnesses at any hearing or at trial, if the prosecuting attorney has such information or it can be readily obtained by him. F. Whether there has been any electronic surveillance of the defendant's premise or of conversations to which the defendant was a party. G. The transcript of any relevant prior testimony, whether before a grand jury or in any other proceedings that may have been held in this case, including but not limited to municipal court testimony. Number 2. Sorry about that. It's time for me to get up and go to work. The prosecuting attorney should disclose and permit inspection and copying of any relevant material regarding A. Any search and seizure of defendant or a co-defendant. B. The acquisition of any statements from the defendant. C. Any police reports made in connection with this case that relate to potential testimony of any police officers or other witnesses. D. Any physical, documentary, scientific, demonstrative, or photographic evidence the state intends to introduce as or use at any hearing or trial. Number 3, the prosecuting attorney should disclose to defense counsel any material or information within his knowledge, possession, or control, or in the hands of any law enforcement agency that could negate the guilt of the defendant or of the offense charged or could reduce the punishment therefor. Number 4, the prosecuting attorney should disclose the name and address of any informant that led to or assisted in making the arrest in this case. Number 5, the prosecuting attorney should disclose whether any requests for or offers of immunity, leniency, sentence or charge concessions, or other inducements have been made by or to any co-defendant, potential witness, or informant. 6, the request specifically includes any audio or video recordings generated of the defendant or any co-defendant and of any scene or area related to the charged offense during the time frame relevant offenses, including any dash or body cam footage related to the charged incident. Number 7, the defendant expressly requests the state provide all discovery required or permitted under the Arkansas Rule of Criminal Procedure. Spencer requests this information be provided as soon as possible. The state should consider this a continuing motion. All information received by the state to the date of trial should be furnished to the defendant in compliance with Arkansas Rules of Criminal Procedure Rule 19.2. This pleading also serves to notify the state of the defendant's intent to assert his right to cross-examine any witnesses who may submit reports regarding evidence in this case. The defendant preserves all of his rights under Arkansas Code and any other provision requiring notice to preserve the right to confront and cross-examine any and all evidence and witnesses. Respectfully submitted. Okay. So now we'll go and okay. Oh, just one second, sorry. Okay, so now we're going to move on to this. Sorry, my dog's going ballistic, but my husband just took her, so I don't have to worry about it. Thank God. But I can't take too much longer because I believe my husband just went to get my father-in-law to come over for birthday cake. So we'll get this going. Oh, shit. Okay. Brief in support of amended motion to dismiss felony information on Fifth Amendment grounds. A, requiring a grand jury for felony charges is deeply rooted in history and tradition because it protects the fundamental principles of liberty and justice. The grand jury clause of the Fifth Amendment to the Constitution provides, quote, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, end quote. Like the U.S. Constitution, the Arkansas Constitution contains a grand jury requirement, and so did the 1868 version of the same document. The purpose of the grand jury requirement is to, quote, limit a defendant's jeopardy to offenses charged by a group of his fellow citizens acting independently of either prosecuting attorney or judge, end quote. The history of the grand jury dates back more than 1,000 years from the... Okay, we don't need to read all that. Is there anything in here related to Spencer case? Okay. Spencer's motion does not require this court to overrule Hurtado, only to read it narrowly. Okay, I didn't even go over Hurtado, of course. So let's back it up a little bit. I don't want to have to read the whole thing that's so lengthy. But it looks like I might have to. So let's just go back. Okay. The history of the grand jury dates back more than 1,000 years from the constitutions of Clarendon and the Assize of Clarendon to the 14th century Edwardian advance in criminal procedural design. In the 17th century, the cases of Stephen College and the Earl of Shaftesbury saw the grand jury emerge as a valued protection of individual liberty against encroachment by the crown through politically motivated criminal prosecution. The Supreme Court acknowledged the venerable history of the grand jury requirement, including its presence in Clause 39 of the Magna Carta and the debates on whether it should be interpreted to include not only felonies but also misdemeanors and petty offenses. In Hurtado versus California, however, the court ultimately decided not to incorporate the grand jury clause against the states, holding that state legislatures were free to, quote, newly devise any legal proceeding enforced by public authority, end quote, so long as they, quote, preserve the principles of liberty and justice. Although Hurtado established that the grand jury requirement was not incorporated against the states, the decision did not excuse states from ensuring that their criminal procedures offered at least some form of due process, and it did not require Arkansas or other states to strike the grand jury requirement from their constitutions. Therefore, in Arkansas and other similar states, the grand jury requirement remained. However, in 1936, Arkansas amended its constitution to provide that, quote, all offenses heretofore required to be prosecuted by indictment may be prosecuted either by indictment, by a grand jury, or information filed by the prosecuting attorney. The following year, based solely on the court's decision in Hurtado, the Arkansas Supreme Court found that Amendment 21 was constitutional within the meaning of the 5th and 14th Amendments to the U.S. Constitution, ushering in an era of felony charges being filed by a lone prosecuting attorney. The state's practice of allowing individual prosecuting attorneys to charge individuals with serious criminal offenses directly controverts the Fifth Amendment to the U.S. Constitution. It also creates the risk of executive overreach, which has no roots in the history or tradition of this country or the state of Arkansas. To protect the Fifth Amendment rights of Arkansans, this court should dismiss the felony information in this case. B. Although Hurtado did not incorporate the grand jury clause, the rationale of Hurtado has been superseded by subsequent incorporation decisions. The right to grand jury indictment is the sole, quote, unincorporated, end quote, outlier among the due process protections contained in the Bill of Rights because of the court's decision in Hurtado Supra, which predated the era of selective incorporation. 1. Although Hurtado treated incorporation as a matter of procedural due process, the court now applies a substantive due process analysis for incorporating the Bill of Rights. Although Hurtado is critically important to the 28 states, including Arkansas, that allow a defendant to be prosecuted for a felony without a grand jury indictment, Hurtado could be called into question in light of the court's decision in Ramos. Okay, sorry. Hurtado could be called into question in light of the court's decision in Ramos. The court's rationale in Ramos reflected the court's rationale in Timms v. Indiana, in which the court explained that a protection enumerated in the Bill of Rights, quote, is incorporated against the states if it is fundamental to our scheme of ordered liberty or deeply rooted in this nation's history and tradition, end quote. A close reading of Hurtado shows that the court did not deny the fundamental character of the grand jury right. Instead, the court acknowledged the grand jury's deep roots in both United States history and tradition and the English history and tradition that preceded the foundation of this country. The court recognized that the grand jury requirement was a safeguard to the fundamental principles of liberty and justice. What it rejected was not the idea that individuals had a fundamental right to be free from deprivations of liberty exceeding the limitations established in the Bill of Rights, but the idea that the Due Process Clause of the 14th Amendment required identical procedural mechanisms in state and federal prosecutions to preserve the fundamental principles of liberty and justice. Okay, let's find where it starts with Spencer again then. Okay, Spencer's motion does not require this court to overrule Hurtado, only to read it narrowly in the context of Murray's lessee. A narrow reading of Hurtado establishes that although a felony information may satisfy the minimal requirements of procedural due process, a substantive due process analysis requires dismissal of the felony information in this case. Number 2, recent incorporation decisions establish that Fifth and Sixth Amendment criminal procedural rights apply identically to the states as to federal prosecutions. As previously established, the Hurtado court did not find a state's process for filing felony charges to be outside the scope of the 14th Amendment's Due Process Clause. Instead, the Hurtado court decided that due process meant any process that was legislatively intended to safeguard the fundamental principles of liberty and justice. Okay, I'm still not seeing anything that really says anything about Spencer. And I don't want to just read a bunch of stuff that doesn't make sense to me, because then I won't read it to where it can make sense to you. Oh, Lord. I think we're going to just move on to the next thing, because this is basically all history on how to indict for criminal charges, and that's what about this one? Okay, we'll do this one. This kind of touches on the same thing the other one was touching on, but this is actually in connection. This is in regards to Aaron Spencer and his case, so that's what we want. Sorry about that. Okay. Amended motion to dismiss felony information on Fifth Amendment grounds. Okay. Comes now the defendant, Aaron Spencer, by and through his attorneys at Lassiter and Casanelli, and for his motion to dismiss this criminal case under the Fifth Amendment to the United States Constitution, states, 1, the court should dismiss this felony information because it violates the grand jury requirement of the Fifth Amendment to the United States Constitution, and stare decisis is not a license for the state to pursue such an unconstitutional course of conduct. 2, following the Supreme Court's incorporation of the Sixth Amendment jury unanimity requirement in Ramos versus Louisiana, nearly every core criminal procedural protection in the Bill of Rights has been incorporated to the states through the Due Process Clause of the 14th Amendment. The court's incorporation doctrine under the 14th Amendment ensures that the minimum content of due process is not subject to erosion by state legislatures. Number 3, the last, quote, unincorporated, end quote, criminal procedural right is the Fifth Amendment's grand jury clause. Whether to require states to comply strictly with the grand jury clause was last considered in Hurtado v. California. That precedent, if read today in light of recent decisions and historical precedent, cannot justify a process that strips criminal defendants of a foundational procedural protection. Accordingly, Spencer respectfully requests dismissal of the felony information in this case. Wherefore, the defendant, Aaron Spencer, respectfully requests that this court dismiss the felony information in this case for violating the Fifth Amendment's grand jury clause. Respectfully submitted on behalf of Aaron Spencer. So, okay. Let's see what else we got. We might have to do this in 2 parts because there's a lot more to cover. So states amendment motion eliminated to exclude evidence. Let's see what that is. The state's trying to exclude some of the defense's expert testimony. Let's see what this is. Okay. Make it bigger for you. State's amended motion in limine to exclude evidence or of expert testimony comes now the state of Arkansas by and through the Lonoke County prosecuting attorney and pursuant to Arkansas rules of evidence and Arkansas rules of criminal procedure, and respectfully moves this court for a pretrial hearing to determine the admissibility and relevance of the 3 expert witnesses disclosed by Spencer and in support thereof states. 1. Spencer's defense counsel served the state with notice of intent to call the 3 expert witnesses at trial and provided the curriculum vitae of said witnesses, which were submitted collectively as Exhibit A to the state's previously filed motion. Number 2. The defense disclosure did not include the subject matter on which each expert is expected to testify, the substance of the facts and opinions to which each expert is expected to testify, or a summary of the grounds for each opinion. Number 3, in the absence of these disclosures, the state is unable to evaluate, and this court is unable to determine whether the proposed testimony is relevant under Arkansas Evidence 401-402, possesses probative value that is not substantially outweighed by the dangers of undue delay, wasting time, or needlessly presenting cumulative evidence, or satisfies the reliability and methodological requirements, or is otherwise admissible. Number 4, a pretrial evidentiary hearing is therefore necessary to prevent surprise, undue delay, and the potential introduction of irrelevant, unreliable, or otherwise inadmissible expert evidence at trial. Wherefore, the state respectfully requests that this court schedule a pretrial hearing to examine the admissibility of the proposed expert testimony of the 3 witnesses noticed by the defense. Order defense counsel to provide in advance of the hearing summaries of the experts' opinions and grant such other and further relief as the court deems just and proper. Respectfully submitted, prosecuting attorney. So, state brief in support of Amended motion eliminate to exclude evidence of expert testimony. Okay. Okay, state's brief in support of amended motion in limine to exclude evidence of expert testimony. Comes now the state of Arkansas by and through the Lonoke County prosecuting attorney, and for this brief in support of the state's amended motion in limine to exclude evidence of expert testimony, states the following. 1. Introduction. Spencer's defense counsel served notice of intent to call 3 expert witnesses at trial. The notice consisted solely of the expert's curriculum vitae, previously filed as composite Exhibit A to the state's earlier motion. The disclosure contains no information regarding the subject matter on which each expert is expected to testify, the substance of the facts or opinions to which each expert will testify, or the grounds or basis for those opinions. No supplemental disclosure has been provided. 2. Argument. Arkansas Rule of Evidence 104 expressly authorizes the trial court to decide preliminary questions concerning the admissibility of evidence, including the qualification of a witness and the admissibility of expert testimony. Such determinations are routinely made pre-trial when the reliability of or relevance of expert testimony is at issue. Arkansas has adopted the Daubert standard for evaluating the reliability of expert testimony. Before any expert may testify under Arkansas Evidence 702, the trial court must determine that the testimony is both relevant and reliable, and that the reasoning or methodology is valid and properly applied to the facts of this case. Without disclosure of the expert's opinions and the facts, data, and methodology supporting those opinions, neither the state nor the court can perform the required Daubert Rule 702 analysis. Even if the testimony ultimately proves reliable, it must still be relevant and not excluded under Evidence 403. Probative value substantially outweighed by danger of confusion, waste of time, or needless presentation of cumulative evidence. These threshold determinations are impossible without a hearing. At this time, the state is left only to speculate as to what the proposed testimony will be, rendering it impossible for the state to make the proper objections under Rules 104. 3. Conclusion and prayer for relief. Wherefore, the state respectfully prays that this court grant the motion and schedule a pretrial hearing on expert testimony. Order the defense to provide written summaries of expert opinions prior to the hearing, exclude all irrelevant and inadmissible expert testimony, and grant such other and further relief as the court deems just and proper. So that's what they call a Daubert hearing, when they get to question the experts to see if they're relevant, I believe. Now let's see. State's response to defendant's notice to raise justification of the defense. Okay, this is This is the state's response to the defendant's notice to raise justification as a defense. The state of Arkansas, by and through Chief Deputy Prosecuting Attorney John Huggins, for its response to the defendant's notice to raise justification as a defense. 1. The defense has provided notice to the state and this court that it intends to raise justification as a defense under Arkansas Code, and then whatever the code is. Number 2, Arkansas case law holds that Arkansas Code or the choice of evils defense should not be given where self-defense and presumably defense of others is also argued by the defendant. Wherefore, the state objects to the defense arguing the choice of evils defense if it also argues self-defense and or defense of others. Respectfully submitted. So I guess they're saying that he can't claim self-defense if he's claiming that he was defending his daughter. Is that what that means? I guess it is. So I don't know. That seems. I don't think he was claiming self-defense anyway, was he? I didn't think he was. For the justification. That's what they're trying to prove. To address is the fact that the defense wants to use justification as a defense. Okay, they filed a lot of things today. So, lucky us, huh? Okay. State's motion in limine to exclude background facts not known to Spencer at the time of the offense pursuant to Arkansas Rules of Evidence. Comes now the state of Arkansas by and through the Lonoke County Prosecuting Attorney, and for its motion in limine states the following. 1. The state moves that the defense be prohibited from eliciting any testimony or presenting any evidence regarding prior misconduct by Fossler that Spencer did not personally know at the time of the shooting. Wherefore, the state requests that the court grant its motion and enter an order barring to alleged prior bad acts or character traits of the victim that were not actually known to Spencer at the time of the shooting. Okay, that was nice and short. That's the way we like them. State's brief in support of its response to defendant's motion in limine to exclude evidence. You know, one of these is going to be, well, this one's 9 pages, so. Let's see. I knew it was going to be too good to be true that they were all short. State's brief in support of its response to defendant's motion in limine to exclude evidence. Comes now the state of Arkansas by and through the Lonoke County Prosecuting Attorney, and for its response to the defendant's motion in limine to exclude. Why is it not sharing? There we go. In motion in limine to exclude evidence states, 1, introduction. Aaron Spencer, hereinafter Spencer, is charged with murder in the second degree in the killing of Michael Fossler. The chain of events leading to Fossler's murder began on July 8, 2024, when defendant arrived at Leanna Higginbottom's house, an acquaintance of Fossler, and told her that he had raped his minor daughter and wanted Fossler's phone number and address. Spencer told Higginbottom, quote, "Don't call anyone, don't call the police," end quote. Out of concern, Higginbottom spoke with a family member about her interaction with Spencer. Her family member, a mandated reporter, was required to report the rape allegations to law enforcement and reported them to Lonoke County Sheriff's Office. That same day, Sergeant John Ingram and Deputy Brian Duke of the LCSO responded to Spencer's residence to open an investigation about the rape allegation concerning his daughter. The interaction was recorded by Sergeant Ingram on his body-worn camera, and a transcription of the relevant portions are included as Attachment A. Sergeant Ingram asked Spencer, quote, "Is there any truth to this?" End quote. Spencer replied, quote, "I don't know." While attempting to investigate the allegations, Spencer was mainly concerned about the identity of the mandated reporter and his beliefs in the inadequacies of the judicial system. Just 1 second, okay? Okay, I'm back. Sorry about that. While attempting to investigate the allegations, Spencer was mainly concerned about the identity of the mandated reporter and his beliefs in the inadequacy of the judicial system. Sergeant Ingram stated to Spencer, quote, "We still don't live in a country where you can take the law into your own hands." Spencer responded, "Bullshit." See Attachment A to State's previously filed response. Eventually, Spencer's wife, Heather Spencer, provided information to the deputies regarding the essay of their daughter. Spencer's daughter was interviewed at the Wade Knox Children's Advocacy Center on July 8, 2024. Cabot Police Department obtained a warrant on July 11, 2024 for Fossler's arrest on 1 count of rape and 1 count of internet stalking of a child, both Y felonies. I'd never even heard of a Y felony before this. Fossler was arrested that same day and taken to Lonoke County Jail. Fossler was seen at his first appearance hearing after arrest by a Lonoke County District Court judge on July 12, 2024, and his bond was set at $50,000. And we all know that's Judge Elmore. She's got a soft spot for rapists. Fossler was also ordered not to have contact with any minor, a violation which would result in his bond being revoked. Fossler made bond on July 17, 2024, and was released with conditions of pretrial release, including the no contact order. On October 8, 2024, at 1:12 a.m., Heather Spencer called 911 to report their daughter was missing. Heather Spencer said they found their daughter's bed made up to look like she was asleep, but was not in the bed. Consistent with Spencer's beliefs expressed to law enforcement on July 8, 2024, Spencer proceeded to take the law into his own hands. Spencer later told investigators that he immediately got in his truck to look for Fossler, stating he was vigilant for him, quote unquote. Spencer left his home traveling westbound on Highway 236. Spencer stated as he was turning on Highway 31 at the intersection of Highway 236, he saw Fossler's white Ford truck past him turning onto Highway 236 eastbound, back towards Spencer's house with his daughter in the passenger seat. Spencer turned around and began following Fossler. He was honking and flashing his lights in an attempt to stop Fossler. After following Fossler for approximately 6 miles, Spencer struck Fossler's truck containing both Fossler and Spencer's daughter. As a result, Fossler's truck was rammed into a ditch, striking a wooden entry gate post. After exiting his vehicle, Spencer then began to fire on Fossler. Spencer continued to fire a total of 16 times. 15 of the 16 rounds entered Fossler. After firing, Spencer pistol whipped Fossler in the face. Then, for the first time that night, Spencer finally called 911 at 1:34 a.m., stating, quote, "Michael Fossler is fucking dead on the side of the road for trying to kidnap my daughter. I had no choice," end quote. Okay, well, their what they're putting in their reports is what he stated, change every time they write a new report, because that's not what they said the last time. They didn't say that he said that. They said, Fossler's, you better come check him out or something like that, but he didn't say anything about he's fucking dead. Anyway, in fact, Spencer had multiple choices that night. Spencer could have called 911 once he discovered Fossler and his daughter. Spencer stated in his interview that he was driving so fast that he could not unlock his phone to call 911. However, a forensic examination of his phone from the minutes leading up to Fossler's killing paints a different story. Not only does the examination show that his phone was unlocked, but was in use. Spencer had a 1-minute, 39-second phone conversation with a family member at 1:16 a.m., received multiple text messages marked red, and called his wife twice around 1:31 a.m., all before calling 911. Spencer also had good reason to believe his daughter had snuck out of the house and had not actually been kidnapped that night. Who cares? She's still a minor in the presence of a 67-year-old rapist, so it doesn't matter if she snuck out. It's still illegal for him to have her. She's a minor. She can't make that decision. Spencer did not want police involved when he initially discovered his daughter was SA'd, nor did he want them involved when he found Fossler with his daughter. Spencer's understandable rage did not give him the legal right to kill Fossler. His belief espoused on July 8, 2024, to Sergeant Ingram that it was quote-unquote bullshit that we still live in a country where you cannot take the law into your own hands, and runs counter to our entire justice system. Number 2, the argument. The evidence that the defense once excluded regarding Spencer's statements that he didn't want police involved in the rape investigation of his daughter, and his implicit comments that he could take the law into his own hands and not be charged with the crime, are directly related to his actions on the night of October 8th. Not only are they relevant statements by a party opponent, the evidence is also clearly admissible under Arkansas Evidentiary 404B, which allows evidence of other acts that are admissible to prove motive, intent, plan, and knowledge. Evidence is relevant if, quote, having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence, end quote. The probative value is not substantially outweighed by any danger of unfair prejudice, and thereafter exclusion under Arkansas Evidence 403 is therefore unwarranted. Spencer's affirmation that one can take the law into one's hands makes his killing of Fossler more probable that it was an extrajudicial act done without any consideration of the law on self-defense or the defense of others. A. Spencer's statements are relevant under Arkansas Rule of Evidence 401. The defendant's statements to Sergeant Ingram on July 8, 2024 are directly relevant under Arkansas Evidence 401 and 402 to the central disputed issue on this second-degree murder case, whether Aaron Spencer killed Michael Fossler knowing his conduct was unlawful without justification. Second-degree murder requires proof that Spencer knowingly caused Fossler's death under circumstances manifesting extreme indifference to the value of human life, or that he acted with the purpose of causing serious physical injury or death. His July 8 statement that the prohibition on vigilante justice is quote-unquote bullshit is evidence that 3 months later on October 8th, he consciously believed he was entitled to act without regard to the law. Just 1 second. Okay, sorry, I had to get a drink. It is probative of an extrajudicial mindset rather than reasonable belief in the necessity of deadly force. If the defense raises justification, the state bears the burden of disproving that defense beyond a reasonable doubt. Spencer's prior and explicit rejection of the rule of law makes it more likely that on October 8th he did not hold a reasonable belief that the use of deadly force was immediately necessary to prevent imminent death or serious physical injury to his daughter. Instead, his statements demonstrate adherence to a personal code under which he viewed the legal system as inadequate and believed that he was entitled to impose lethal punishment on his own. The evidence will show Spencer had multiple realistic opportunities to call 911 while continuing to follow Fossler and his daughter before ramming Fossler's truck and firing 16 rounds. His phone was unlocked and in active use. His July 8th statements provide the motive for that deliberate choice. He had already announced that reliance on law enforcement and the courts was, in his view, quote unquote, bullshit. This directly rebutes any suggestion that his failure to call police was the result of panic, incapacity, or reasonable belief that law enforcement could not respond in time. Arkansas Rule of Evidence 401 defines relevant evidence as evidence having any tendency to make the existence of any fact that is of consequence more probable or less probable that it would be without the evidence. Spencer's declaration that citizens should be allowed to take the law into their own hands has a clear and powerful tendency to make it more probable that A, he acted with the prohibited mental state on October 8th, and B, he did not act with the reasonable belief required for justification. In short, the July 8 statements are direct proof of Spencer's rejection of the very legal principles that stand between second-degree murder and a justified homicide. They are therefore relevant and admissible in the state's case in chief. Okay, well, but they're not charging him with justified homicide. I mean, they're not charging. Oh, I see what they're saying. Okay, he wants it to be justified homicide. Okay, never mind. B, probative value of Spencer's statement substantially outweighs any danger of unfair prejudice. It is well settled that most evidence is, by its very nature, prejudicial, and that evidence must be unfairly prejudicial to be excluded, end quote. Only evidence that tends to suggest a decision on an improper basis, such as raw emotional reaction, is excludable. The Arkansas Supreme Court has repeatedly emphasized that evidence offered by the state in a criminal prosecution, quote, is likely to be prejudicial to the defendant to some degree. Otherwise, it would not be offered, end quote. That's true. Otherwise, it wouldn't be evidence, right? Accordingly, exclusion under Rule 403 is proper only when the defendant demonstrates that the danger of unfair prejudice substantially outweighs the evidence's probative value. We heard that a lot in the Karen Reed case. Probative value versus evidentiary versus prejudicial value and all that shit. And yeah, I didn't really understand it then, and I don't understand it much better now. The Supreme Court's application of this principle, well, I can't say I don't understand the concept. I don't understand how most of the judges rule on it, because it seems like they rule the opposite direction that I would have ruled had I been the judge. So I don't think I'm understanding it to the extent that I think I am. So anyway, the Supreme Court's application of this principle in Demas Martinez is instructive and strongly supports admission here. In that case, the court upheld the introduction of evidence that the defendant, 1 month before a murder, possessed a loaded magazine containing the exact type of ammunition later used to kill the victim, even though the possession occurred during an unrelated traffic stop and had no connection to the homicide itself. The court found that the evidence probative of access and planning, and held that any incidental prejudice did not substantially outweigh that probative force. Just 1 second. Okay, my VPN came back up, so I don't know if it's going to cause problems now, because I had it off for 2 hours and now it's back up. So hopefully it doesn't cause any problems. I don't know if that's what's causing my audio problems. See, I think it might be, because now I'm having issues again. Okay. The July 8th statements in Spencer's case are extensively more probative than the ammunition magazine in Demas Martinez. They are not remote or circumstantial. They are Spencer's own rejection of the legal principle he later violated when he executed Michael Fossler. Just as the magazine tended to prove the defendant's ability and preparation to commit murder in Demas Martinez, Spencer's explicit contempt for the prohibition on vigilante justice directly proves his motive, intent, and absence of justification on October 8th. If evidence from an unrelated traffic stop a month earlier cleared the Rule 403 hurdle, evidence of the defendant's own recorded philosophy of lawlessness uttered in the same investigation that gave rise to the homicide easily satisfies the balancing test. The state seeks admission only to prove Spencer's state of mind and to rebut justification. Therefore, no improper basis is invoked. The danger of unfair prejudice is negligible. The probative value is overwhelming. Rule 403 does not require exclusion. C. Spencer's statements are independently admissible under Arkansas Rule of Evidence. Even if the statements were considered, quote, other acts, wrongs, or crimes, end quote, evidence, which they are not, because expressing a belief as Spencer did is not itself criminal conduct, they are squarely admissible under the well-established 404B exception. Arkansas Rule of Evidence 404B provides that evidence of other crimes, wrongs, or acts is not admissible to prove the character of a person in order to show that he acted in conformity therewith. It may, however, be admissible for other purposes, such as proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident. Here, Spencer's recorded assertion that it is, quote, bullshit, that citizens cannot take the law into their own hands, is independent evidence of motive, intent, plan, and knowledge, and absence of justification. It shows a pre-existing vigilante ideology that drove his actions and advance awareness that his course of conduct was illegal and that he proceeded anyway, and also disproves that he did not act under a reasonable belief that deadly force was necessary, but instead pursuant to his previously announced contempt for the legal system. He never once voiced contempt for the legal system. Roman numeral 3, conclusion and prayer for relief. The defendant's July 8, 2024 statements to Sergeant Ingram are relevant under Rule 401 because they make it substantially more probable that Spencer killed Fossler with the culpable mental state required for second-degree murder and without any lawful justification. Their probative value in revealing his mindset, motive, and intent far outweighs any danger of unfair prejudice under Rule 403B, or 403, sorry. Independently, the statements are admissible under the Rule 404B exception as direct proof of motive, intent, plan, knowledge, and absence of mistake or justification. Because the statements satisfy Rules 401, 403, and 404B on every level, the defendant's motion in limine must be denied. Wherefore, the state requests this court to deny the defendant's motion and allow this testimony to be elicited by the state in their case in chief as a statement by party, opponent, and or under Arkansas rule. Respectfully submitted, Chuck Graham, prosecuting attorney. So, I think we're going to have to finish the other two in my next stream because I need to get off here. I have prior engagement. But I want to thank you all for joining me and giving me some more chances to prove that I can make this channel work, and hopefully I can. Please like and subscribe. I put the link for Aaron Spencer's sorry, I'm mixing up GoFundMe with his. It's, now I can't even think of what it is. Give, Send, Go. Sorry. Account is down in the description. So if you can, please donate please donate what you can for his legal funds, because we all know that, lawyers aren't cheap. especially if you want a good one. So until next time, I hope to see you guys again soon. Please be safe and take care.